your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Hello, everybody. Welcome. TGIF. And you know what that is. Thank God it's Friday. And today's docket is Judge Aaron Gauthier. Again, I would like to thank all the people that are subscribed to this channel. Without you guys, I couldn't do this. Hello, Joanne. Without you guys, I couldn't do this. I think the new content is working out because it's less stressful on me. I don't want to talk about the drama. I think the whole thing is a shit show, and I don't want to be a part of it anymore. And to have respect for John Cook, who it may or not be the John Cook, we're thinking of, just out of respect for him, not to talk about it. So I decided, somebody suggested doing court cases and talking about court stuff, which is fine by me. I don't mind doing it. There might be a schedule change coming up. So I think it's not going to be by judges anymore. It might be, I don't know, it depends. It may end up being like a Monday court docket, a Tuesday court docket, a Wednesday court docket, a Thursday court docket. Friday will be landlord-tenant. Saturday will be a coffee chat. And then Sunday I'll be off. I can look into it. I'll look into it. So let's get started with Judge Gauthier. Yeah, I just didn't want to do the drama stuff anymore. The channel was dying, and I decided, well, you know what? I'll just do. Somebody suggested doing court cases and court stuff, And yeah, I mean, I'm just new at this, so please be patient with me. I do a lot of research. While this is playing in the background, I'm doing research on getting other content to add to the content to the channel. I don't even watch it anymore either. I don't watch it anymore either. I was watching Squid for a little bit before I came on while I was setting up everything. Let me get started with Judge Gauthier. Jeez. So let me make this bigger. As big as I can make it.
There we go. Can you hear me now?
Yes, Your Honor.
Okay, sorry. All right, well, good morning. We are on the record in 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And our first case this morning is the State of Wiggins v. Wiggins. It's filed 24-9024CH. Counsel, you want to state your appearances, beginning with the plaintiff?
Good morning, Your Honor. Bradley Martin appearing on behalf of the plaintiffs. My client is also appearing today via Zoom.
Okay.
Good morning, Your Honor. Alexandria Taylor appearing on behalf of the defendants. I have a few of them appearing via Zoom as well, Judge.
Okay, great. And good morning. This is a continued final pretrial. Looks like the second amended complaint was filed and answered. And there's of course the estate of Theron is in default, and all the other defendants, Ms. Taylor, you're representing, is that right?
That is correct, Judge.
Okay, but then I thought I saw an entry ROA. Are you representing was there a Laura Lynch that came into the case or no?
Your Honor, that was former counsel for plaintiff.
Your Honor, that's the counsel as substitute. I was going to mention that as like a housekeeping item.
Yeah.
Attorney Lynch contacted me that she got a notice from the court, and it appears that maybe the substitution was only processed for either Mildred Wiggins or the estate, and she's still on one of them, and the substitution was supposed to be for both Mildred individually and as personal representative.
Okay, great. All right, great, thank you.
Yeah, I was headed to a nursing home, but then I discovered a 30-second trick that gave me my memory back.
All right, very good. So looks like the second amended complaint's been filed and answered. So where are we at then, Mr. Martin, about readiness to set for trial or any resolution anticipated or any pretrial issues that remain?
Yes, Your Honor. So I just today sent Attorney Taylor a discovery request for Ann Wiggins, as well as a settlement offer for 4 of the defendants. So the settlement negotiations that are ongoing would only resolve it to potentially some of the defendants. So I think it would be fine to go ahead and set the matter for trial at this time, because I don't foresee a resolution, a universal resolution that would take care of the entire case.
All right, Ms. Taylor, do you concur that the case is now postured where we can schedule it for bench trial?
I do concur, Your Honor.
Okay, and Mr. Martin, how How many days do you believe that you would need?
Your Honor, I think when we had initially discussed, it would be approximately 3 days, just given the number of defendants involved. I have some additional witnesses, but just the number of parties involved in the type of case, I would think 2 days at the minimum. 3 days probably would be more likely.
Okay, Ms. Taylor, how many days do you believe is necessary for the trial?
Your Honor, I agree to some extent. I would say probably closer to 3, no more than 4. And again, as counsel stated, just the sheer number of witnesses that we have, it's just going to take time to get through the testimony.
Okay, let me look here. Review the calendar here. Finding 3 days in a row is a little trickier to do, of course.
Excuse me.
Okay, I could give you a Monday, Tuesday, Wednesday, November 17, 18, and 19. Does that work, Mr. Martin?
I'm available, Your Honor. That would work for me.
Ms. Taylor?
I can make that work.
So let's schedule it for bench trial November 17th, continuing as needed into the 18th and 19th. I'll require trial briefs not later than 7 days before the start of trial. Anything further from the plaintiffs?
No, Your Honor. Thank you.
Anything further from the defendants?
Yes, Your Honor. As the court is aware, some of our defendants are very elderly and may not be able to travel. Would the court consider, I mean, obviously I'll be there in person and majority of us will be, but some of them are in their 80s, 90s, and may not be able to come to court for trial, especially, mid-November when the weather may be impacted. Would the court consider allowing some of the elderly witnesses to testify via Zoom?
I think it being the trial, probably what we ought to do is have you start by talking with Mr. Martin about that.
Okay.
And if you guys have a stipulation as to video appearance from certain witnesses, you could just submit those stipulations that I'd sign.
Okay.
If you find that there's somebody that you want to appear by video conferencing, that Mr. Martin objects to that, then you can file a motion and notice it up on a civil motion day before the trial, and I'll consider at that time under the standards in the group court rule about that.
All right. Thank you, Judge.
Okay, thank you. You guys have a great day.
Thank you, Your Honor.
All right, Mr. Wood, can you tell me what case you're here for?
Judge, I'm a special assistant AG, and I was assigned to cover the Manson-Stoneham Circuit Court arraignment. I know a lot of times these circuit court arraignments aren't on the record, but I didn't hear back from Mr. Vogler. Michael Vogler is the attorney. So Manson-Stoneham, can you tell me what the status is, Judge?
Yeah, that was that's a Presque County, child support felony. That is not
Right.
on today. I don't know. It might be on next Monday, August 11th. If I could ask you to call my, my circuit court staff, when you leave this call, the number is 231-627-8818.
Okay.
And ask them, they can tell you when the next scheduled appearance is.
Thank you very much, Judge. I'll do that. I appreciate it. Have a good week.
Okay, thank you. You have a good day. Murphy Rogers, I received a stipulation for, and that is off. All right, so let's go off the record for a second. I'm sorry, Mr. Charles, was it?
Yes, sir. Yes, sir. So, Your Honor, just briefly, this motion for preliminary injunction arises out of a property dispute involving a strip of property between the Hopt and Ramsey properties, immediately south of the Hopt property, immediately north of the Ramsey property, of which Ramseys are the current record title holders. The motion is extremely limited as to the relief Mr. Hopt seeks in a couple of regards I just want to speak to. Number one, he's only seeking injunctive relief to continue using that part of the disputed property, which my client has historically used to come and go from his property, even though the entire disputed area involves a much larger area of property. And it also involves uses beyond simple access. And also the claim on which my client relies to establish likelihood of prevailing on the merits for purposes of today is his claim for prescriptive easement only. And so the remaining claims, at least in our assessment, they're not really relevant to what you're here to consider today. So with that said, I'd like to start the conversation with respect to the first factor of the four-part test, which the court evaluates when considering a preliminary injunction, which is likelihood of success on the merits of the underlying legal claim. Here, Mr. Hopt's claim for prescriptive easement. In his background, the Hopts purchased the first of two parcels they would ultimately acquire from the Dockets, who are both the predecessor in title of both Mr. Hopt as well as the Ramseys, back in 1964. At that time, the Hopts commenced using the disputed area for purposes including ingress and egress and parking to access their lakefront lot from Man Road via a long private road easement that runs through the Docket, now Ramsey property. My client provided an affidavit, which is Exhibit R to his complaint, which we also attached as Exhibit A to our motion, establishing that he did use the disputed area in this manner, again, for egress and ingress for at least 15 years, which again is the statutory period, both for adverse possession or for purposes of today, prescriptive easement. And just as, of course, a easement by prescription is established in the same manner as adverse possession, albeit the claimant need not establish that the use was exclusive. So that element is removed for purposes of prescriptive easement claim. And that's set forth in the Marionette Auto Wash v. Van Dyke, Michigan Supreme Court case 501 Mich 192, 2018. So regardless of whether Mr. Hopt can establish exclusive use, which again is not at issue today, his affidavit does establish the remaining elements for a prescriptive easement for ingress and egress. That is, the use was actual, it was continuous, which I understand Ramseys are disputing, and I will speak to that in further detail momentarily, that it was open and notorious, that the use was hostile, which I understand is also being disputed by the Ramseys, and I'll speak to that as well. And
Yeah,
again,
can you, I guess, on the factor on likelihood of success on the merits, just
We've been using IXL for as long as my kids have been in school as just a supplement.
Maybe jump to there. I don't need to go through all of the elements of prescriptive easement. Really, the one that seems most at issue is the defendant's claim that any use was permissive use.
Sure, Your Honor. So the issue with their objection or argument as to the permissiveness of the use is that they're only disputing that, at least as I read their response, that permission came into play once they acquired the property in 1984. Our position is that the prescriptive easement had already vested as of 1979, when the Docket still owned the property when the statutory period ended, 1964 to 1979. And so they provide zero claim, evidence, or even argument that the Dockets provided my client with permission to use the disputed area from 64 to 79. And in fact, Mr. and Mrs. Docket's daughter provided an affidavit attesting that she is unaware of any such permission from her parents. And she always thought the disputed area actually belonged to the Hops because they're the only ones that used it when her parents owned the property. So the fact that the Ramseys allegedly gave permission once they acquired the Docket property in 84, our position is that's legally irrelevant because the prescriptive easement had already vested as of 1979. And again, we'd rely on the Marionette auto wash case for that proposition. So again, we believe we've established a very strong likelihood of success on the merits with respect to Mr. Hopp's claim for prescriptive easement. And I would also note, I don't think it's relevant for today, but we're also disputing the permissiveness that Ramseys are alleging started to occur as of 1984.
But when was the turnabout driveway constructed?
Turnabout driveway was constructed somewhere in the neighborhood of 1984 to 1986, is my understanding.
Right. So that's what's confusing me when I looked at your affidavits. That your client's continued use of the Ramsey property on a prescriptive easement seems to be, I guess, it coexists with their expressed need to use their turnabout driveway, right? So they use their turnabout driveway, and then the prescriptive easement is the egress at the back end of that turnabout driveway.
I would, and I apologize if that wasn't completely clear from the affidavit. So I think the distinction there is the area that they're claiming that they're entitled to use via prescriptive easement. They've always used that tail that's now been impeded by the Ramseys. The turnabout driveway just changed the nature in which they used the tail, because previously the tail was used for both ingress and egress. Once the turnabout driveway was constructed, then it was primarily only used for exiting the property, but it was the same area that was previously used before the construction of the turnabout driveway.
So the point of ingress on the turnabout driveway was a new point of ingress in 1984 to 86. Is that what you're saying?
That is my understanding, yes, Your Honor.
Okay, go ahead, continue.
And I believe as to continuity, this is a seasonal property. It's recreational in nature. I think it's well established that somebody that has a cottage or a recreational property can have a claim for adverse possession or prescriptive easement, and it's contingent on the nature of the use of that property. And I have some cases for that proposition, if that's something that the court is.
No, I think that's, especially in Northern Michigan, that's a fairly self-evident point that folks don't have to use it in the dead of winter to maintain continuous use.
Thank you, Your Honor. So unless you had any other questions as far as the underlying legal claim, I can move into the irreparable harm factor, which I believe is also contested by.
Yeah, and that was the largely the reason why I denied the temporary restraining order, as you would have seen from obviously from the opinion, is why is there an irreparable injury requiring preliminary injunctive relief when, without using the back end of that turnabout driveway, your clients in fact have an ingress and egress to their premises?
They do have an ingress and egress, but logistically, it is incredibly difficult to navigate leaving the property without the use of the tail area that's in dispute. Mr. Hopt is an older gentleman. He's always traveled to his summer cottage, most recently since he moved to Florida, for probably the last 20 years, for the period of May to October. This is the first year he has not returned to Northern Michigan for that period of time, because he is simply not comfortable, particularly given his age, trying to either negotiate a multi-point turnabout within the narrow constraint of his property, or backing back out onto the private road easement and turning out in that fashion. When we actually filed the TRO, and I know Your Honor did have some questions as to the timing, and I do want to point out that when this originally happened, it was a somewhat fluid situation last fall as far as this development with the Ramseys contesting Mr. Hopt's use of this area. We did explore other means of trying to resolve the situation short of litigation, if that was possible. So there was some time spent exploring those options. And I think more importantly, my client wasn't scheduled to return to Northern Michigan until May of this year, which is, in our mind, that's when the actual irreparable harm would no longer be theoretical in nature. And in fact, he hasn't returned. He did come for a brief period of time in June when the original motion was scheduled on the preliminary injunction, and he hasn't been back. And that is,
This moment feels heavy.
Medical facilities are overwhelmed.
This moment feels loud.
I was not thereby trying to fault folks for talking to their neighbors before going to the courthouse.
Understood, Your Honor.
But then when you file an ex parte temporary restraining order saying now we want relief without even giving the other side a benefit to be the opportunity to be heard, I'm very careful about that, because that implicates a lot of due process issues and should only be used in truly emergent situations. And so I was just noting that it's hardly emergent when you waited 6 months to file.
And we respected the opinion on the motion for TRO and did follow I think the suggestion.
So that's why this is the better way to do it, where I'm going to hear from you and then I'm going to hear from Mr. Martin.
Yes, Your Honor. So again, our position is that this is irreparable harm because, again, he's losing the ability to use his real property, and there really aren't monetary damages sufficient to compensate him for that. And moreover, even if there were, they would be incredibly difficult to ascertain what those damages are. And again, we are, and I think moving into the third element, which is, well, what's the potential harm to the Ramseys here? Well, this has been the status quo from 1984 to 2024, as far as Mr. Hopt's use of the turnabout, or that area of the disputed property for ingress and egress, and now primarily just for egress. And again, we're only asking for removal of that portion of the fence line that actually obstructs his ability to egress the property through the turnabout feature, and then removal of any personal property materials that would otherwise prevent use in that fashion. So we're not asking for the whole fence to be removed at this time, just the portion of the fence line that's obstructing his ability to egress the property through that feature. And again, I think it's also important to note that when the fence was initially installed, my understanding was it was done without a permit, and it was actually put in backwards, whereby the unfinished side of the fence was facing the Hopt property rather than the Ramsey property. That was later corrected, but it was done in a very short period of time. So I don't think that removing a small section of the fence is a huge risk to the Ramsey family. And even if we are ultimately unsuccessful as to our underlying claims, clearly they can have, and your order could even be conditioned on them being reimbursed for their costs as far as removal and reinstallation.
Well, it's not so much removal of a small portion of the offense that would be the irreparable harm, as I understand it. It would be, just the ability of a property owner to vindicate their property rights and exclude somebody that they wish to exclude.
Agreed, Your Honor. But again, our position is we've established that not only a likelihood, but a strong likelihood of success on the underlying claim for prescriptive easement.
Okay. All right. And as to any public interest?
Public interest, I don't really view that as a huge factor in this case, but it seems to me that first responders, public utilities, and any other member of the public that happens to access the hot property will be better served if they can pull out using the turnabout feature rather than trying to, again, negotiate the difficult multi-point turn within the hot property or backing out back onto the actual easement itself and leaving the property in that fashion. And I believe we did attach an affidavit from Mr. Hopp's daughter, Wendy Bartle, kind of highlighting the difficulty she experienced along with some photos doing that, particularly when there was snow on the ground earlier this spring, and also when there's multiple family members at the property. Again, it's a family cottage, so it's typical for the family, right? Not everybody carpools up together. So when it's used like it's typically been used in the past, there's often quite a few family vehicles at the property using it.
Can I ask you then, in terms of the irreparable injury to the plaintiffs, when I look at the photographs that were attached to your pleadings, especially if it's only used in the summer months, as you've expressed, there's also, it looks like, various unimproved areas that would allow backing up on grassy areas. I mean, if I just you take judicial notice of a fact of the world in northern Michigan, the number of residences, including cottages that you drive by that have turnaround driveways, is a very small minority of driveways. Most driveways to residences and cottages have a single point of ingress and egress. And folks have to navigate that, and they do it hundreds, thousands of times every single day in our county. So it's a bit hard for me to wrap my brain around the fact that your client's saying that they have to do what everybody else does every single day is irreparable harm. Help me understand that better.
Sure, Your Honor, and I appreciate the opportunity to expand on that a little bit. One issue is that the area immediately north of so in other words, if you're facing the Mullet Lake in the wrapabout driveway feature, that's where the septic field and septic tank is. So that's an area that really vehicles should not be traversing for I think what the court could take judicial notice of. The other issue here is that, again, when the cottage and the turnabout driveway feature was put into place in the mid-'80s, it was constructed sort of with the idea that it would have this turnabout driveway feature to leave the cottage. So, I mean, that was kind of intricate and part of the design as far as where the cottage is situated, other structures that were eventually put on the property, including a garage. So I understand that you are correct that there's plenty of properties that that have very limited property for parking, and vehicles do have to back out, but that's never been the nature of this property, at least since it was improved.
Having the anchor solix in my home gives me the confidence that I can keep on fighting against.
Oh. All right, thank you. Anything else I need to know to understand your position?
I think that's all, Your Honor, for the moment.
Okay, thank you.
Mr. Court, need anything from me?
Huh?
Does the court need any argument from me?
No, I do have one question for you. What's your response to the claim that your argument of permissive use is too little too late because the prescriptive easement was established before your clients owned the property?
Because they never considered or used that portion as a turnaround, which is evidenced by the fact that he paid thousands of dollars to have a paved driveway go all along the line of the border and stopped right at the edge. If he honestly believed he had a right by way of an easement, he could have continued it on, but he stopped. And the second thing is that they came and asked permission from the Ramseys to allow PI&G contractors to bury their fiber cable along that easement line. And so if they honestly thought they had easement rights and utilities, they could have used it. So there's no likelihood of success on the easement and no irreparable harm.
All right, thank you. Can you rebuttal?
Just very briefly, Your Honor. One, I'm not sure that the client has to have an honest belief whether they owned it or not. They met the elements of easement by prescription, whether they knew they'd established those or not. So I'm not sure that their knowledge really matters. Secondly, the fact that they didn't pave, as you said, thousands of dollars. I mean, there's a lot of other reasons why they would have chosen not to pave the other area that they're using to pull through, especially when there's a tree line and sort of an island there that shields it. I mean, they paved the part that's visible from their property that they wanted to pave. And as far as the PE or the utility lines, I think that there was, again, I don't think that knowledge of whether my client thought that he owned the area via adverse possession or had prescriptive easement rights or otherwise would defeat those claims. And I think it was more of a courtesy to say that we're going to be having utilities put in someplace. And it was more of a notification to the Ramseys that that process was going to happen and approximately where they were going to go. I don't think the intent there was to request permission, again, even if that was even relevant when that happened, just in the last several years.
Okay, thank you. All right, well, the plaintiffs have used the, the plaintiff has used this turnabout driveway for ingress and egress to his property, at least in the summer months. The point of ingress is within his legally owned premises, but the point of egress requires them to traverse part of the defendant's property. And then I guess last year, the defendants put up a fence which had the effect of prohibiting or stopping that use of egress at the back end of the turnabout driveway. Plaintiffs have filed suit saying that they have established a right to that property or the use of it under different legal theories, one of which is a prescriptive easement, and they're asking for a preliminary injunction that while the case is being litigated, that they can continue to use, that the plaintiff can continue to use it as he has used it historically. The court considers 4 factors for whether to grant preliminary injunctive relief. This, of course, is not the trial. All I've done is review materials submitted by each side and heard arguments. This is really just a question of a significant remedy before a plaintiff proves that they win, should they essentially win in the meantime until we have the trial. That's sort of what a preliminary injunction is, and it can be done to maintain the status quo. And so that's what the plaintiff says, well, this is just maintaining the status quo. So when I look at the 4 factors, first, reasonable likelihood of success on the merits. This is not clear cut to me. The plaintiff says, well, I have established my prescriptive easement before the Ramseys even owned the property. I established it by 1979. However, the use that he's wanting today is use that really wasn't established until 84 to 86. He's wanting to continue to use the turnabout driveway, which wasn't installed until the Ramseys, owned it, and the Ramseys have presented evidence that they've continued to give permission over the years and have withdrawn their permission, which might or might not be very neighborly. I have no idea at this point, not having heard the proofs, but it would be their right. So I think where the requested use postdates the claims of permissive use, I'm not sure whether a different pre-permission use would satisfy that. I have some questions about that. So I think it may well be the plaintiff will prevail, but it may not. I can't say today that it's clear in my mind that there's a reasonable likelihood that they're going to win. Second, and even more important to the court, will the plaintiff suffer irreparable harm if I don't grant the preliminary injunction? I think the answer there is no. The plaintiff has a driveway.
Your membership is more than just a card. It's your
To their property. They can enter that, they can leave that. They're saying, well, gee, it's a burden to turn around instead of using the turnabout driveway. So as I posed the question, the plaintiffs are basically saying, the plaintiff is basically saying, me having to do what thousands of property owners do every single day in Sheboygan County is an irreparable harm. I just can't see my way there. And it's only used in the summer months, and there's unimproved areas where they can turn about. And on the photograph submitted by the plaintiff, it's not just where the septic is, there's other points as well. There's some inconvenience to the plaintiff. And when the plaintiff says, well, gee, when lots of people visit my house, it makes it hard to get in and out of the driveway. That again is true for thousands of people every day. If they have visitors to their home, that congests their driveway and it makes it more difficult to enter and leave their premises. That's just ordinary stuff. So I just don't know that there's any irreparable harm to the plaintiff to the extent that it would justify a preliminary injunction. Third, will the injunctive relief harm the defendants? Well, yeah. I mean, if the defendants are correct that this is their property, well, it is their property legally, but if the defendants prevail that the plaintiffs have no right to use this, then the court ordering the defendants to let the plaintiffs use it is this court and the plaintiffs then trampling on the property rights of the defendant. That's a harm. If it was clear that the plaintiffs were likely to win and were irreparably harmed if I didn't grant relief, well, then of course I would. But I think on the balance here, there is no real harm to the plaintiff, and there would be some degree of harm to the defendants to allow the use. And I don't think the public interest is seriously implicated here. So the fourth factor is really not relevant. So on the whole, I'm going to deny the request for a preliminary injunction. And again, that's expressing no opinion about, whether after having heard the case at a trial, whether the plaintiffs would in fact prevail or not. Just on the standards for granting relief up front, I don't see that those standards have been set. Mr. Martin, as the prevailing party, can you submit a vote?
Will do, Your Honor.
All right, so we are here also for a scheduling conference. So are the pleadings satisfactory to the plaintiff?
They are, Your Honor.
Defense?
Yes, Your Honor.
Okay, any amendments would require leave the court?
Not that we are aware of at this time.
Okay.
Not for defendants.
All right, have the initial disclosures been filed by both sides?
Yes.
Yes, Your Honor.
All right. Mr. Charles, how long do you need for discovery?
I was going to request 120 days, Your Honor.
Is that fine, Mr. Martin?
Sure.
Witness list within 60?
Of course, Your Honor.
Any proportionality limits on discovery being requested by the parties, or all discovery permitted by the court rules?
We're not aware of anything that would require a specific address by the court at this time.
I agree.
Okay. I understand the new court rules to require me to ask that, and nobody's ever said, yes, we want some limits on discovery for proportionality. Is this something where you'd want me to order the parties to facilitated mediation, or is that something that you attorneys can sort out if you think it's suitable at some point?
I'm not opposed if the court orders mediation.
Mr. Charles?
If Mr. Martin thinks it's fruitful, to a certain extent, I guess there's some zero-sum determination here that, the parties would have to be able to negotiate on. So if he thinks that those discussions.
Well, especially when they also are neighbors, I think I'll go ahead and order a facilitated mediation. So the court will enter order of that. Usually the order will give you a period of time to select a mediator if you both agree. If you don't, I have to pick from our list. And I'm not allowed, as I understand the court rules, to pick from my list a mediator that I think would be suitable for the facts of the case. I just have to pick the next one up. So it's in your interests to agree on one that you think would be suitable. All right, and this being there's no jury demand, right? This is a bench trial?
Bench trial.
Okay. What would be the estimated length of trial?
Probably 2 days.
That was going to be my number as well, Your Honor.
All right, and with a bench trial, I don't push the parties to a settlement conference with me, because I'll be the trier of fact. If you feel comfortable and want to do a settlement conference with me at the end of discovery in chambers, I'll go ahead and do that if you wish, and then you guys can drive the bus about how much you share. Do you want a settlement conference with me at the end of the case or not?
I think it'd be worth having.
No objection.
Okay. All right, so let's see, that'll be, we'll give it 4 months.
You're not going to believe what happened. Tell me everything. I'll show you on Monday.com. So I started the biggest.
Your Honor, I believe there's a strong likelihood we'll bring a dispositive motion. Is there a time frame in which you'd like that to be heard for motion?
Yeah, usually if you could have that heard prior to the settlement conference, would be great. So the discovery period will end in early December. So maybe we'll schedule it for a settlement conference in January 2026. I'll get a date from my staff and send out a notice to you both. Anything further from the plaintiff for purposes of scheduling?
No, Your Honor.
Mr. Martin?
All set.
Okay, thank you. We'll get the scheduling order out to you.
Thank you.
All right, then up next we have Kramer v. McGinnis.
Ready, Your Honor.
This is file 25-9099. Counsel, you want to state your appearances, beginning with the plaintiff.
Your Honor, Jennifer Schaefer here on behalf of the plaintiff, Robert Kramer.
And Mr. Martin is here for defense, Mr. McGinnis. And Mr. Martin, I had previously granted the defense motion for summary disposition, and defendant has now filed a motion for costs and fees. I've reviewed the motion and the response. Mr. Martin, go ahead.
Thank you. Defendant moves for recovery of attorney fees as set forth in the text affidavit to our motion. The basis is that this was a complaint that should never have been brought, lacking factual evidence and not doing a thorough legal examination of the theories. Evidence, as the court may recall, is that they filed a count that was far exceeded the statute of limitations. Their claims for the publishing failed to assert or allege that they requested a retraction. It's required by statute. The citations in the complaint were skewed and misrepresented to the court as complete and accurate. They were not. We showed that at the summary disposition hearing. And in addition, plaintiffs missed all deadlines and initial disclosure, witness exhibit lists and all that. This was done nothing for harassment. This was protected political speech, as the court noted time and again. It was done for harassment purposes. We asked the court to grant our relief.
Thank you, Mr. Martin. Ms. Schaefer?
Yes, Your Honor. I'm sure the court is aware there are three possibilities for a frivolous complaint. One that is brought to solely to harass, embarrass, or injure the other party, or that the person who brought it had absolutely no reasonable basis for believing the factual allegations, or that there was no legal, possible meritorious legal argument. And this request for attorney fees and cost fails on all three. In terms of any request or any intent on the part of the plaintiff, Mr. Kramer, to harass, embarrass, or injure Mr. McGinnis, I do believe the affidavits of 20 witnesses, 20 members of the community who have actually witnessed the meetings, witnessed Mr. McGinnis's behavior, witnessed his statements, witnessed his physical attack on the Mr. Kramer and other board members. All of those affidavits, I think, speak volumes as to the fact that this is not a situation of Mr. Kramer in any way, shape, or form trying to embarrass, harass, or injure Mr. McGinnis. It is exactly the opposite. Mr. McGinnis is the one who has engaged in a sustained campaign for over 2 years of the intent to harass, embarrass, and injure the reputation of Mr. Kramer. As for whether or not Mr. Kramer had any basis to believe his factual allegations, again, this isn't something where he just believed what he was saying. He has been backed up by these 20 witnesses to say this occurred. And I actually don't think there's much dispute as to the statements being made by Mr. McGinnis. It comes down to the intent and the interpretation and the context. And as we point out in our brief here, context is everything in every defamation case. Yelling fire is an entirely different matter, depending on whether you're standing outside a house that is burning and it is on fire, or whether you're standing in a theater and there is no fire. So the context and the circumstances mean absolutely everything. And in this case, I realized it was a rather unusual one. This is one that is not taking a single statement, looking at it and saying that's it, that's the entire case. I would point the court to the most recent case on Mr. Moran, the Ironworks case. We're talking about there a single statement, made on the radio, and that being enough for someone to come into court and say, and it was, there's been some general statements made, people that say nothing more than this person has just stopped lying. He's been lying about a lot of things. People sue over that. And it is, if it's not true and does injure that person's reputation, well, that's defamatory and you can bring a complaint on it. In this instance, I think the court struggled with the way the complaint was stated is that we did put them into individual counts. And that's because we do believe that, in fact, each statement itself is a matter of defamation. However, we fully agree with the court, too, that looking at them individually and not in context, you could say that, well, why would you bring a complaint over it? I believe that the court's reference was to, anyone who sits in a political office should grow a thicker skin. And that would, in past times, certainly that might be the way it goes. But I think we attached the article kind of detailing what things are happening now around the country, and not to, exaggerate, or make too big of a deal of it. This is, not quite the same situation, but that's a concern. That's what caused Mr. Kramer, and I think you can see from his wife, Nancy Kramer, and also other affidavits, people that were scared, people that were very, very concerned about these statements, the conduct, escalation, and what was happening. And that's the basis for bringing it in that context and looking at everything as a whole. And I would ask the court to remember that we didn't even get through discovery or even have an opportunity to depose Mr. McGinnis or his wife or anyone else. And so the ability to bring that forth, and also in a more full fashion, as well as the opportunity to amend the complaint if the court's concern is with stating them individually and it doesn't make the case
you
there.
said that a lot, and that's not my concern at all. I mean,
okay.
I was asking you to justify some of them, and you couldn't. You simply couldn't. And at the summary disposition motion, they said, well, why justify why I shouldn't grant summary disposition on count 3, a specific count, and you couldn't. And I think that's proper line of questioning, but all of them put together, my still fundamental problem is this is a citizen standing at a public meeting during public comment and criticizing a public official for the performance of his public duties, which makes it different from any other cases I may have pending, which I'm not going to comment on, but commenting about a public official's performance or malfeasance or misfeasance or nonfeasance in the performance of their public duties is at the heart of the First Amendment. He's not standing there and saying, Mr. Kramer in his personal life is doing X, Y, Z, totally unconnected to his public service. Well, that may very well have been defamatory, but all of this was about his performance of public duties, wasn't it?
Yeah, I was headed to a nursing home, but then I discovered a 30-second trick that gave me my memory back. Now,
Each of the statements did in some fashion relate to something going on in public duties. I would not say that each statement made at the time had any relation to what was at issue in that meeting or what was in front of anyone, but in some way you could argue that it had some relation to what Mr. Kramer does in public life, particularly because Mr. Kramer's public life is not simply sitting at board meetings. He also engages in many other community activities. And so things that Mr. McGinnis said may very well relate to conduct of Mr. Kramer that is in public. Your Honor, this, I have to say, you know, when I've never seen anything like what we have here, where I said to Mr. Kramer at the last hearing, you know, obviously we knew we had a reason to bring this. We certainly had no intent to harass or injure anyone. Firmly believe the factual basis, firmly believe that there is a meritorious legal argument to be made about the overall context of all of these statements together being defamation. But what I wanted to do was, you know, have a kind of a double check. You know, let's ask other people. And Mr. Kramer asked people, you know, you tell us, what have you seen? What did it cause you to feel? What did you think? What you saw? Did you see it as someone simply coming into a public, you know, meeting and speaking about, you know, public activities in a normal manner that anyone would want to protect his
normal
free speech?
manner? Normal. See, that's the thing. A lot of the affidavits, one of them called the plaintiff an angry leprechaun. I'm not sure why you thought attaching that is helpful to you, but that was impolite. But you know, so is Mr. McGinnis' stuff impolite. So the normal manner thing. So whoever it was that called Mr. McGinnis the angry leprechaun, is that defamatory? No. No. Is it impolite? Sure it is. And all of those affidavits were friends of your client or community members who say, we don't like the way Mr. McGinnis comports himself. And they described a situation at a meeting that they thought might have been an assault. Well, that wasn't what was pled in this case. This is a defamation case. So that was neither here nor there. So again, the manner that he's speaking it, unless he's disrupting a public meeting to where he's being removed, you know, there's no requirement that the First Amendment be polite. I mean, there's protests, there's all sorts of things. So it's the substance of the statements. And I still am not hearing you even today explain to me why the substance of statements of a citizen criticizing a government official for the performance of his duties is actionable.
Your Honor, there is where I think the substance of the statements requires looking at the context in which they're made. And I do believe that is something that I think every defamation case, you know, the United States Supreme Court, from starting with, you know, New York Times versus Sullivan, says the context matters. And actually, I have to say that with regard to Mr. McGinnis not, you know, acting out of order, he did. This is part of the problem, is that he did. The police report disturbing the peace. He was actually, he had a deferred sentence on this. He was charged. They literally had to put into place having police at every meeting after that.
You
because
didn't
of
sue him
his
for what he did.
conduct.
You sued him for what he said.
What's that?
You didn't sue him for what he did. You sued him for what he said.
I fully agree with that statement, Your Honor. My point is, again, any words must have context. You can't look at it in a vacuum in terms of, again, fire where there is a fire when you're standing in front of the building is different from fire screams in a crowded theater. You have to look at the circumstances and the context rather than simply the words by themselves in a vacuum without any context at all. And in this situation, when you have someone who has disrupted meetings, who has attempted to physically assault board members, who has required people to bring in police at every meeting, who has then caused other people to fear for their safety at meetings, to stop going to public meetings so that they can have their right of free speech, because this person has been out of order so many times. When you look at it in that context and then say, okay, so now he is accusing Mr. Kramer of public corruption. He's accusing him of stealing from the Veterans Affairs Administration. These are, again, technical defamatory statements that can damage someone's reputation. They are not something that one single time someone making it in a public forum without any other instance ever occurring would go to court over, and we would not encourage that at all. But in this context, to say that simply because, and we understand the court's ruling, you know, we certainly understand the summary disposition And in that matter, that makes Mr. Martin and Mr. McGinnis the prevailing parties. But that does not in any way make them entitled to say that we have a frivolous claim where, again, we have not done anything to make this frivolous. This was brought with the legal argument that is viewed in context altogether over time as a campaign of defamation. Also that the each individual statement can stand on his own as being technically defamatory, not such that someone should go in for a single statement. And the idea that Mr. Kramer is the one here who has done anything to try to embarrass or injure Mr. McGinnis, whereas, and again, I would speak to the affidavits. I would say to the court this: we did not ask anyone to write anything. We didn't tell anyone to write anything. We didn't edit because we wanted the people to be able to say and to swear to what they wanted this court to know. And so they did. And I understand, you know, someone calls a name, a cartoon character name, the court is saying that's, you know, so what, that's not an issue. And I would agree.
It's not having access to 1 million industrial grade products that's so amazing. It's the feeling of knowing.
But then it comes back to then why is it that, you know, in Mr. Kramer's case, you know, if he is repeatedly, again, in his words, attacked over every single thing he does, and in terms of crimes, then at what point does he ever get to say enough is enough? And again, I would say the context of this is looking at political violence now is a real concern, and it occurred in this case. And that's the context in which we brought this. That's the basis for it. I would ask the court to not find that this is in any way frivolous. Thank you.
Okay, do you have any other objections to the requested relief?
No, I cannot dispute his hourly rate or, yeah.
Mr. Martin, any rebuttal?
No, I don't think so.
All right, well, it's unusual for the court to order one side to pay the other's attorney fees and costs. That's known as the English rule. The American rule is generally that each side bears its own freight. There are some statutory exceptions, and there's also an exception if a complaint is frivolous, which doesn't happen very often, as it shouldn't happen very often. The defendant says, well, in this case, the plaintiff's complaint was in fact frivolous. And frankly, I agree. As I said at the hearing where I granted summary disposition, this is not a hard case. This is core First Amendment protected speech. This is a citizen during public meetings, during public comment, criticizing a public official for the performance or non-performance or wrong performance of his public duties. Ms. Schaefer today sort of does a bait and switch and says, well, in the affidavits, there were other things that, other allegations or that were included that weren't part of the complaint. We're here today to not say what other things is Mr. Kramer unhappy about with Mr. McGinnis, or what other things are people in the community unhappy about with him. We're here to say, of the allegations that were in the complaint, were they frivolous? They were. I mean, it's surprising to me, Mr. Kramer filed it on his own. And then as Mr. McGinnis filed his answer, I think, on his own, and then lawyers got involved after the fact. I have to say, I'm a bit surprised that there's any lawyer that wouldn't have told Mr. Kramer, you ought to dismiss this case before you got to reach in your pocket here. And when I pushed Ms. Schaefer multiple times, explain to me what's defamatory about these statements, she just can't, other than saying it's the context and now trying to describe the manner in which Mr. McGinnis stated them or his behavior at a meeting. Again, that's not what he was sued for. What he was sued for was the content of his speech. And the content of his speech was a citizen criticizing a public official. You can't get more First Amendment-y than that. This is, I think, quite clearly a claim that was brought without any legal merit whatsoever. It is, in fact, frivolous. I have reviewed, there's been no objections to Mr. Martin's proposed bill of costs. I did review it under the standards under Smith v. Curry and Pergo v. United States Auto Association. I did review the state bar's economic survey of the practice of law. And Mr. Martin's bill is a little bit north of the median, but it is a bit south of the 75th percentile. He's an experienced and skilled attorney in the community. This involved constitutional claims that he had to, or constitutional defenses he had to research. So I do think that the hours and rate are reasonable. And looking at the factors to adjust them up and down, I saw no reason to adjust them either up or down. So the motion for costs and fees is granted in the amount claimed, $9,415. Mr. Martin, you can submit an order.
Thank you.
Thank you. We're going to move into our family division docket for a bit, so terminate the live stream.
Mr. Worthington is 70 years old, has no criminal record, has lived his whole life in the city of Lansing.
On August 22nd, I told viewers that the road to artificial intelligence is already bringing massive.
All his family's in the greater Lansing area. He's the cousin of one of the named partners at my law firm, George Sinus, who obviously has as a person of significant standing here in the Ingham County legal community. And I would represent that there is absolutely no risk whatsoever of Mr. Worthington not appearing for future hearings in this matter.
All right, absolutely. The court will grant a $100 personal recognizance bond. Mr. Worthington, you do not have to post any money. The conditions that apply to you are simply do not miss any court dates, do not violate any state or local laws while you're on bond. Does that make sense?
It does, Your Honor.
Good, good. Then, Mr. Larkin, did you have anything else for the record, sir?
Nothing, Your Honor. Thank you very much.
All right, thank you, gentlemen, for your appearance. You're all set. You're free to go. Just watch your mail.
Thank you.
You're very welcome.
Thank you, Your Honor.
All right, bye-bye.
He's checking out upstairs. His name was Terrence Lonnie.
Oh, he's not on the docket.
Yeah, I didn't see him over there.
Okay.
And contempt or bond violation hearing. And People v. Oliver Hill. It's file 24-6932FH. Counsel, please state your appearances.
Melissa Goodrich, Wayne County Prosecutor.
Luke Kukoski on behalf of Mr. Hill, Your
Honor. All right, good afternoon. Mr. Kukoski, do you know how we're proceeding today on the docket call and on the contempt matter?
Well, Your Honor, I believe my client would like a hearing in the matter.
Okay, Ms. Goodrich, any opening remarks?
No, Your Honor.
Okay, Mr. Kukoski, any opening remarks?
Well, Your Honor, we plan and intend to, through the hearing, show that my client, although had some deviation in the monitoring of his ankle device, there was no alcohol use. There was no alcohol that can be testified to. And in fact, my client did take a urine test amidst all this deviation and tampering, alleged tampering of the device. And I'm not sure what defendant in their right mind would do that. So we're prepared to go forward with those proofs.
Okay, and Ms. Goodrich, your first witness.
I'd like to call Lainey Fryer, please.
I do see Ms. Fryer in the Zoom meeting room. All right, Ms. Fryer, can you see and hear us?
I can, Your Honor. Thank you.
Okay, would you please raise your right hand for me?
Mm-hmm.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, Ms. Goodrich.
Thank you. Can you start by stating your name for the record, please?
Yes, Lainey Fryer.
And
Your
where?
Honor, I guess I would object to testimony by Zoom, given the nature of the hearing, the burden of proof beyond a reasonable doubt. I would ask the court and ask that have the witness be in person here.
Ms. Goodrich, your response?
Your Honor, I believe that the court rules allow for discretion of the court to use Zoom, and typically the practice of this court is for bond and probation violations that we do use Zoom testimony for efficiency for the witnesses who are often far away and needing to travel otherwise.
All right, Ms. Fryer, we're going to continue with your testimony by Zoom right now. The prosecutor has some questions for you.
Thank you. I think we left off on where you're employed.
I'm employed at Home Confinement Incorporated.
And what is your position there?
I am the Director of Business Development and the Director of Compliance.
Okay, and how many years have you been employed there?
I've been with Home Confinement for 4 years, and prior to that, I worked in the judicial system for over 30 years as a probation officer, court reporter, and Director of Probation.
Thank you. And are you familiar with the defendant Oliver Hill?
I am.
And are you familiar with the Scram Systems non-compliance report for Oliver Hill's case dated April 14th of 2025?
Yes, I do have a copy of it in front of me right now.
Okay. And what was the non-compliance in this report?
The non-compliance, the date of the non-compliance, confirmed event, April 14th, 2025. And if you flip to page 4, it's going to verify that it was a confirmed tamper event with alcohol detected. That does not mean it was a confirmed alcohol event. It just means it was a confirmed tamper event with alcohol detected.
Okay. And can you further explain what that means? What constitutes a tamper event?
Absolutely. And if I don't know if you would like counsel, but I can explain briefly the technology behind the cam prior to going into that, or I can just go right into it.
Yes. No, if you could explain the technology first.
Absolutely. So the cam alcohol tether acts like a breathalyzer, but it's worn on the ankle. It is designed to pick up transdermal alcohol concentration. And what that is when a person ingests alcohol, the alcohol will be metabolized throughout the body, except for 1%, which comes out in impermeable sweat vapors. So the alcohol tether is designed, it takes a reading approximately every 30 minutes through a faceplate, similar technology to fuel cell sensor. It's going to pull in a sampling, and it's going to determine whether or not there is a TAC, transdermal alcohol concentration, within that sweat vapor. That's one of the technologies, the primary technology. The couple other technologies of this device is it has a IR infrared technology, and that is to determine whether or not there is a tamper. If one is trying to tamper either intentionally or unintentionally with the equipment. So the IR infrared at the time of installation is going to take a baseline reading, infrared reading of that, the fit. And what that's measuring for is the light reflected between the alcohol tether and the skin. Our manufacturers always want to give the benefit of the doubt to the user. So there is an allowable 12% deviation of that IR baseline reading, because we know people are walking, the bracelet is going to be moving a little bit around the ankle, but it still should fit tightly like a wristwatch around one's wrist. So the infrared is going to pick up these readings, and when there is a 12% or greater deviation for 3 hours or more, and this is also listed on page 3 if you want to follow along. When there is a deviation of 12% or more for 3 hours or more with the presence of alcohol, that will trigger a tamper event. Now, without the presence of alcohol, meaning without a TAC reading, without the presence of alcohol, that window is expanded to 8 hours or more. So a user would have to have something in between their skin and the tether. And once again, that tether fits snugly around the ankle for 8 hours or greater before there is a tamper alert that is triggered. There also is a temperature technology on it as well, but basically that's going to take into account the person wearing it, their temperature, as well as external, if they're outside playing basketball, it's going to be hotter in the summer versus maybe shoveling snow in the winter. So that technology is really to determine whether or not an offender actually cuts off the device. And there has been an incident where someone has passed away and we saw a huge dip in the temperature reading. So I just wanted to mention all 3 technologies that were designed into the tether.
Okay, and in this case, the confirmed tamper was without alcohol detected?
No, this confirmed tamper was with alcohol detected, but it's not a confirmed alcohol event, meaning that I cannot testify today whether or not he ingested any form of alcohol because it did not meet the criteria required to come back as a confirmed alcohol event. I can testify that there was a confirmed tamper event, and the details of that event are listed on the bottom of page 4.
Thank you. And does the home confinement, when they issue a tether to a defendant, is there a protocol on instructions on how to wear the tether and what to do and not to do?
Yes, there is. And Mr. Oliver did sign it. If you want to just wait 1 second for me, I can pull it up. I can even email it to you if you need, and I can read it to you verbatim if you just give me 1 moment.
Yeah, I would object to the witness testifying or reading verbatim from a report that's not been admitted as an exhibit. I understand refreshing recollection and refreshing memory, and the fact the witness is looking at a report to do so. But we're getting very close to the line of where I think it's improper.
Okay, so
Ms. testifying based on this.
All right, so Ms. Fryer, if you don't look up something while you're testifying then, okay? So
Of
just
course,
testify from your memory, and then the prosecutor will go from there.
Absolutely. I was just going to try to read verbatim, but absolutely, I can tell you. And we do give each offender a packet of it's the client agreement, a packet. Within there is going to contain the rules of the do's and don'ts of wearing the alcohol tether. We do indicate in there that they are not to consume, ingest any form of alcohol.
I would object. It's not been a question asked of the witness, and the witness is testifying to in general's opinion. It's not based on a specific whether Mr. Hill has gotten that material or not.
She's answering the question that was asked before your objection, and she's describing their general procedures, which is admissible. Continue, Ms. Fryer.
So we speak about, what products to avoid that contain any form of alcohol, cleaning products, colognes, etc. In there also, we talk about that they cannot get anything in between their skin and the tether, as that could possibly prompt a confirmed tamper event. So that is also written within the body of the document that we do provide each offender.
Thank you. In your honor, I'd move to admit People's Exhibit 1, which is the Scram Systems Non-Compliance Report, which we've been discussing.
Okay, Mr. Gutowski. Any objection?
So I have an objection to the foundation of the exhibit that's being offered. There's been none laid at this time, Your Honor. And so I'd object to the admission of that.
If you want to lay out the foundation.
Yes, so the Scram Systems non-compliance report, when there is a violation of the tether, this is a report produced by your company, correct?
That is correct.
And this is the regularly used format of the report when there is a violation by a defendant.
That is correct.
And you've had the time and ability to review this report, and it accurately reflects the report of Oliver Hill. It says report date Wednesday, April 16th of 2025.
That is correct.
Your Honor, I move for the admission of People's Exhibit 1.
Mr. Kukowski, any objection?
I would still have a continuing objection, Your Honor, to the foundation.
Okay, overruled. Exhibit 1 submitted.
I have no further questions.
For the cross-exam.
Yep. Do you know when Mr. Hill was placed on the Scram unit?
Yes, he was installed on January 31st, 2025.
Okay. And when did the deviation or I guess alleged tampering occur?
So once again, I'll reference page 4 of the admitted document. At the bottom, it goes through the criteria. To answer your question, it's number 3. The deviation outside of the acceptable variance began on Monday, April 14th, 2025 at 9:08 a.m.
Okay. And so he's had that device. Were there any other tampers alleged on that device?
No, Counselor, this was the one and only violation that Mr. Hill received. He was placed on cam January 31st of this year, and it was deactivated on May 5th of this year.
Very good. And so over the course of about 3 months, this is the only violation or tamper event that you would have in your system?
That is correct, sir.
Okay. And you cannot confirm or testify to any sort of alcohol being involved with that?
No, that did not meet the criteria required to come back as a confirmed alcohol event. So I'm only able to confirm the tamper event that we're speaking of.
Okay. And you would admit that these devices are not perfect. There's a variation of about 12% that give or take for the reading of the infrared. Is that correct?
No, that's not correct. There is probably, these devices are about 99% accurate. When we're speaking about the 12% deviation, that's not an error. What it means is that the light reflectivity that the IR sensor shoots out an invisible beam of light, and it's measured in voltage. That means that there was more than a 12% change in voltage that is required over a specific period of time, either 3 hours with the presence of alcohol or 8 hours without the presence of alcohol, that would be required to come back as a confirmed tamper.
Okay. So there's a window there. It's not a perfect system. You just said it's about 99% was your testimony, but there is variations that occur, and these are not perfect devices, correct?
These devices are about 99% accurate.
Okay. And as regards to the temperature variation here, those variations occur whether the client's outside, they can change, whether they're inside working. Those conditions cause the temperature reading to change, so there could be a variance there as well, correct?
Yes, but the temperature variance has nothing to do with the confirmed tamper. It's a different technology.
Okay, well, your report indicates that the tamper technology contained in this trace at page 2 includes both infrared sensor and temperature sensors. So to determine whether a violation or a tamper has occurred, it clearly indicates that there needs to have the infrared sensor and the temperature sensor.
Yes, but he did not cut off this tether, nor did he pass away. That's when the temperature sensor would come into play with a tamper, when we would see a complete uprise of the temperature or downrise, which is not really the case in Mr. Hill's situation. He did not cut off the tether. There was just a confirmed tamper, which occurred for a duration of 1 day, 16 hours, and 20 minutes, meaning that something got between the tether and his skin for almost 2 days before the tamper event did resolve, and it turned back to baseline on Wednesday, April 16th at 1:28 a.m.
You aware of any issues that Mr. Hill would be having with his device that he reported them to Ms. Fenlon, the person that installed it?
I have no information of that, and I will also say that the device does a self-diagnostic test approximately every 8 hours, and if there was an issue with the device, we would be notified immediately. The last time this device was serviced and calibrated was June 14th of 2024, and it takes 365 days of actual wearing use of it before we're required to do an annual maintenance on it, and neither of those scenarios did occur with Mr. Hill.
So in your paperwork, there's nothing to show that that device was actually serviced by Ms. Fenlon. We had an ice storm up here, and she went to everybody that was wearing these devices and serviced those. That's not in your report or your information.
It's not in the report I have in front of me right now. No, Counselor, it's not.
Okay. And so when there is a tamper going on such as this, where we're talking about over the course of longer than a day, do you notify the agency to notify the client that's wearing those devices?
And just to go back, I think the ice storm, that's when Ms. Fenlon went to people's houses to direct connect their tethers because people were without power. And the tether can actually store like up to 6 months of data. But I believe she drove to individual houses to direct connect and download that data into our mainframe. So I think that's what she did. And then the second question that you just asked me was in regards to do we notify, how we do the notification. So when there's either an alcohol event or a tamper event, the event must come to a completion for that information to be reviewed. And then if it gets reviewed and comes back as a confirmed event, then home confinement sends a report to the judicial entity, whether that be pretrial services, probation, etc. And then they review that, and then they're the ones who determine whether or not they're going to issue either a bond condition violation or a show cause hearing. We are just the electronic monitoring agency, so we report any violations and any confirmed events to the judicial entity.
So your testimony is that reporting only occurs after the event has taken place and goes back to normal?
Yeah, see, the alcohol tether is different than the SoberLink. SoberLink, you're going to get immediate results. I blew a .10 at 101 on today. It's going to give you that information. The alcohol tether is designed to capture an alcohol drinking or a tamper event. So we must wait. That's the way it's designed. You wait till the event is completed before that information is analyzed for either not confirmed or confirmed results, at which point that information is forwarded to the courts. So we wouldn't want to send any violation if it's still in process and it hasn't been reviewed. We can't do that.
So a violation could essentially be never ending.
Potentially, I guess, yes. I've never seen that, but potentially.
Yeah. Those are all the questions I have, Your Honor.
Can you redirect?
No, Your Honor.
Ms. Fryer, I have a question, if you could help clarify for me. The report says that alcohol was detected during the tamper, and you testified about transdermal alcohol from the skin, but then you also testified it didn't rise to some level for you to confirm an alcohol event. Can you describe for me the difference between alcohol being detected and a confirmed alcohol event?
Yes, I can, Your Honor. And in some instances, when there is an interference, meaning a tamper, something is placed in between the skin and the tether, then that alcohol detection technology can be compromised. So to answer your question, in regards to the strict protocol with that's required for a confirmed alcohol event. So we must start with a TAC, a transdermal alcohol concentrate of 0.000. That TAC level must reach to a peak state, then return back to a 0.000, meaning that event, that bell curve completed. The absorption rate must be less than 0.100 TAC per hour, because our bodies cannot absorb more quickly than that. And the elimination rate must be equal to or less than 0.035 TAC per hour, because once again, our bodies cannot eliminate more quickly than that. And then it also needs to pass the environmental contaminant factors, which could be anything that the device picks up environmentally. So for an instance, we had an offender who worked at a bar and someone spilled some beer near his ankle. So we saw a significant peak with that TAC reading and then a significant drop. But it did not come back as a confirmed alcohol event, because there would be no way our human bodies could absorb and then eliminate the TAC that quickly. So in this instance, the alcohol that was detected did not meet that strict protocol. Could it have been because there was a tamper? It could have been that because there was a tamper, that it couldn't do its job technology-wise. It was compromised because of the tamper.
Okay, so there, when there's alcohol detected, there was some transdermal alcohol detected by the sensor. But for whatever reason, those reasons could include the fact that the device wasn't functioning properly due to a tamper. You can't say what in the world was going on with any alcohol at all.
Yes, to answer your question, Your Honor, yes, there was a couple TAC readings that were received by the device, but it did not meet the strict protocols I went through with you. And therefore, it did not come back as a confirmed tamper event. It just came back as a alcohol detected, because there was a alcohol detected. There was transdermal alcohol concentration levels that were detected. It just did not measure up and meet the strict criteria required.
Okay, thank you. Ms.
You're
Goodrich,
welcome.
any questions as a result of the court's question?
Yes. Ms. Fryer, if it starts to detect alcohol, can the device be tampered by the defendant to prevent the full reading to be the alcohol to be confirmed?
Yes, as I did indicate, if something is placed between the skin and the alcohol tether, that could interfere and compromise the technology of the device to function properly, the way it's designed to function.
Okay, thank you.
Mr. Kukowski, any further questions on that topic?
Just briefly, Your Honor. And Ms. Fryer, are you aware of the CAM activity report, which says that the scram detected no alcohol events?
When I spoke to you earlier today, Counselor, when I returned your phone call, that is a moot point, because it's not a confirmed alcohol event, and that does not really come into play here, because I'm not here to testify that he did consume alcohol, because it was not a confirmed event.
Thank you.
All right, thank you, Ms. Fryer. You're excused. I'm going to remove you now.
Thank you, Your Honor.
Any further proofs, Ms. Goodrich?
No, Your Honor.
Mr. Kukowski, any proofs from the defense?
I would be calling Oliver Hill to the stand, Your Honor.
Okay, Mr. Hill, if you want to come over to the witness stand here. As you arrive, if you can, as best you can, raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, you can see it there.
State your name for the record, please.
Oliver Winston Hill, the third.
And Mr. Hill, we're here today regarding an alleged bond violation that occurred here in April on the 16th or the 14th through the 16th. Are you familiar with that?
I am.
And the violation that's been alleged?
Yes, I am.
How long have you been wearing that ankle monitor, that tether?
Since January 31st.
Okay. And do you recall that device having to be serviced by Ms. Fenlon at any time during the time you've been wearing it?
Yes, I do.
When was that and what was the services?
It was just about 2 days before the storm that we had. She contacted me, came to my home, took it off my ankle, and I believe that she changed the battery in it because she assumed that we were going to lose power.
Okay. Were there any other times?
No, that was it.
Okay. Did you not, in fact, see her due to a problem when you arrived in the county jail?
Yes, I did.
And what was that for?
It was a little bit loose on my ankle.
Okay.
And there was a screw loose on it.
Okay. And Ms. Fenley came in and serviced that for you?
Yes, she did.
And when was that?
It was Sunday.
Okay. Now, during this time, you've been wearing that alcohol tether and you've been on the monitor there. You've also been doing urine screens. Is that correct?
Yes.
How often are you doing those?
In the beginning, it was twice a week. And then 1 week, I went like 3 days in a row. And the following week, 2 days in a row. So it was basically 5 days in a row. So I called up to the court. I said, something doesn't seem right, you know? It's a lot of days in a row. So they reset it. And then after that date, it was once a week after that.
Okay. And did you in fact test and produce a urine screen on the 15th of April?
Yes, I did.
And did you get the results of that test to provide them to the court?
Yes, I did.
And I'm going to show you what's been marked as defense's proposed exhibit A. Do you recognize that exhibit?
Yes, I do.
And how do you recognize it?
I've seen it before.
Is this the test that you got from them?
Yes.
Regarding the test that you took on the 15th?
Yes, it is.
Your Honor, I move for the admission of defendant's exhibit A.
Any objection?
Your Honor, I haven't seen it.
Okay, you want to show it to them?
No objection.
All right, exhibit A is admitted.
And the results of that test, can you tell me what they were, Mr. Hill?
They were negative.
Okay. And on the 15th, did you come to the courthouse, as a matter of fact?
Yes, I did. Right after I did the urinalysis.
What were you here for?
I came here to turn in my my SoberLink device.
What'd you see?
I took it. I first called Megan Fenlon, and she told me to bring it here and to give it to Emily Wergu.
Okay.
So I turned it in, and then I came upstairs and I went to the circuit court to inquire about a sobriety court, and then on the way downstairs, I seen Your Honor coming up as I was the last flight of stairs.
Okay. Do you recall what time that was and when?
It was probably about 1:30-ish, approximately.
And if that test that you took on the 15th indicates that you took that test at about 11 o'clock, maybe quarter to 11.
Okay.
Did that verify your timeline better?
Yes.
So you would have came to court after taking that test, so maybe close to noon or 12:30?
Correct. I'm sorry.
And so you're here in that building, how long were you here?
Not too long, probably about 10 minutes, possibly a couple more.
Have you had any other, since the time you've been placed on the alcohol tether and you've been urine screening through there, has there been any other violations or any other incidents?
No, there had not.
Now, you had Ms. Fenlon come in and service your device because of a loose screw and broken plate, did you say?
Your Honor, it's already been asked and answered.
Just
Sustained. I promise I'm paying attention.
promise you're paying attention. Okay. Do you know how your device and the screw got loose on that device?
I have no idea, no.
Did you have any indication from Ms. Bennett on how that might have occurred?
I'd object as to hearsay.
Sustained.
Those are all the questions I have, Your Honor.
Can you cross?
No, Your Honor.
You can step down, Mr. Hill. Any further proofs, Mr.
The
Perkins?
defense would rest at this time, Your Honor.
Any rebuttal proofs, Mr. Hill?
No, Your Honor.
Argument, Mr. Hitch?
Your Honor, I would ask the court, based on the testimony of Lainey Fryer, to find that there was alcohol detected, even though it wasn't a confirmed event. It sounds like even the defendant can interfere with that being a confirmed event. And therefore, the tampering was a violation. Mr. Hill had been incarcerated due to SoberLink and violations. He was released and then returned to jail after this tether tampering, which had detected alcohol. As far as his testimony as to the battery being changed, or he said on Sunday, so May 4th, the nail or screw being tightened, I don't think that would interfere at all based on Ms. Fryer's testimony with the science behind the tampering. Thank you.
Thank you, Mr. Kukowski.
Your Honor, we're here today for a bond violation in which my client has been alleged to have tampered and had a confirmed alcohol detection with his device. The burden of proof is on the people, and that burden would be beyond a reasonable doubt. At this time, the only testimony that we have from Ms. Fryer is that, well, there's deviations in this machine. It's about 99% accurate. I would question whether those devices and the admissibility of those devices, even in court, to meet that burden of proof. Again, my client has readily admitted any violations that he's had in the past. He's come to court, he's fallen on the sword, he's taken his lumps. He would, and I wholeheartedly believe would admit to a violation if he had one here today. But that's not the case. He's admitted maybe 3 violations in the past just on this file alone. He's had this device on his ankle since the 31st of January. Almost 3 months go by before there's any problem, any issue. He's done 17 drug urine screens in the meantime with no problem, no issue, no problem with this device. He's come to court on the 15th. If he's tampering with this device, sticking something in there to mess with the infrared sensor so he could drink alcohol, why the heck would he come to court in the county building on that day? And why the heck would he go drug test and drop urine on the 15th in the middle of this alleged violation and this alleged tamper event? Oliver Hill's a bright guy, but he's not that dumb to do that, Your Honor. And there's just not enough evidence or testimony that has been placed on this record today that would indicate to me, or should indicate to the court, that there has been a violation and that a violation has occurred. Mr. Hill has complied with this order. He's adamant he hasn't tested. He's testified today that Ms. Femin had to service that machine. A screw was loose on that machine upon entering the jail. Again, 83 days on that device, on that machine. And it wasn't until the 80th or just less than that day that he's alleged to have been tampered from this report. The report ends on the 23rd. So a significant period of time has lapsed. If there was a relapse or there was alcohol use, it would have occurred sooner, Your Honor. We'd ask the court to find that there has not been a violation of this matter. The prosecution has not met their burden of proof, Your Honor. Thank you.
Thank you, Ms. Goodrich. Any rebuttal argument?
No, Your Honor.
All right, well, I'm going to find Mr. Hill in contempt of court for tampering with the alcohol tether. There is some question about whether alcohol was consumed or not. The alcohol detection on from the skin can't be confirmed that it was an event of consuming alcohol for the reason that, or it could be for any number of reasons, and one of them could be the device being tampered with, which that interferes with its ability to detect alcohol. That seems, I'm not surprised by that. That seems rather common sense. one mitigating fact there is on the 15th, right in the middle of the detection, right of the tamper window, there is a negative alcohol urine test collected on the morning of April 15th. The tamper with alcohol being detected continued past that date till the early morning hours of April 16th. But it's not really clear whether there was any alcohol being consumed or not by Mr. Hill. But what is clear is that there was something being done to interfere with that device's proper operation, which is designed to test for the presence of alcohol. So I think there certainly is proof beyond a reasonable doubt that Mr. Hill is in contempt of court for tampering with the device. So he's found in contempt. As to sanction, Mr. Kukuski, any
Your Honor, again, Mr. Hill, throughout this case, has readily admitted any problems or any violations that he's had with alcohol and alcohol use. He was incarcerated for 50 some days with a prior violation, and he's very adamant that this time he's not using or consuming alcohol, and it can't be, that fact can't be proven here today and was not proven here today. I would ask that the court allow him to be back out on bond on his device. He's got a lot of cleanup to do and work to get done. As I indicated the last time that we were here, the court was so gracious to put him on the ankle monitor, and he was very grateful. We are very grateful. We stand here very thankful to the court to allow us that opportunity. He went 3 months before this alleged tamper device, and I don't know how that happened, how the screw came loose, if his plate had gotten cracked and Miss Fenton had fixed it. But regardless, there was an issue with that device. It has been serviced, it has been fixed. And so given that and the time that he set now on this violation, waiting for his hearing, I asked the court to just sanction him to that time served, allow him back on bond so that he can provide for his family, take care of his mother, and do the things he needs to do to get his home clean since this whole event has happened in the ice storm. So thank you, Your Honor.
All right, thank you. Mr. Hill, you don't have to say anything, but before I decide on your sentence for the contempt, you are allowed to tell me anything. Is there anything you want to tell me about that or no?
Your Honor, I didn't do anything to this. I didn't tamper with it. I did the drug test. I had no idea that there was anything. It wasn't a sock. There was nothing in between my ankle and that device.
Right, thank you.
That's all.
Mr. Rich.
Your Honor, Mr. Hill, as mentioned, had violated on his SoberLink, which sounds like he had admitted to. Now he's violated with his tether. I believe he is a risk of public safety, and 93 days should be ordered with his bond continue to be revoked. It looks like the incident date of this underlying case is July 2nd of 2024, so it may be time for trial to be set.
Thank you. Well, I don't know whether Mr. Hill is guilty of the drunk driving that he's charged with or not. He has the right to a trial about that, and we need to be scheduling one here. But when he's got 5 prior drunk driving convictions and at least 4 or 5 prior felony convictions on top of those, and a revoked license, and it's alleged that he's out with all that history driving drunk on that revoked license. So there's conditions placed on his bond so that we can be assured that Mr. Hill isn't placing the community at any risk of harm. He violated those bond conditions by using or drinking or both, and I revoked his bond. And then he sat 56 days on a revocation of his bond. And then, I think a lot of local attorneys can tell you, I don't give second chances when there's a violation of bond in that nature in a drunk driving case. I'm not entirely sure why I did for Mr. Hill, but that is not the norm for me to then cut you back loose into the community. But I did, but with a tether. So now I know I want continuous monitoring of your skin so that I can know that by me putting you back out, despite that prior violation, that I'm not endangering the public by putting you back out there among them. And, you know, we've got evidence that I found that you tampered with that device. So that's just makes me regret reinstating bond in the first place, to be honest. So the sentence for that second contempt, the first one was 56 days. The second contempt is certainly not going to be less than that. So this will be a 93 days in jail, credit for 14 days previously served. Bond will continue to be revoked. So even at the conclusion of the contempt sentence, you can't be released again until I decide to reinstate the bond. All right, so Mr. Krukowski, that takes care of the contempt issue. As to the underlying case, where are we at in terms of docket call?
Well, Your Honor, I did receive a recent emailed offer from the prosecutor that I was just discussing with my client to see whether that was something that he'd be amenable to. Your Honor wants to set this matter for trial in a few months, then maybe an interim docket call so that we could discuss that.
Well, maybe I'd like to set it for trial if we're going to try it. I don't want to set it for trial if we're going to resolve it. So maybe I can have this come back next week, or you're not here on, you're not available on the 13th, is that, or are you available?
I don't believe I am available. I don't have my phone with me, Your Honor.
The only thing I've got you on is for Smiley for arraignment or plea taking. Oh, and Wheeler.
Smiley and, I'm sorry.
Wheeler.
Okay.
So I mean, I could add this to next week's docket.
Let's do that. And
then you can review the offer with your client. And if it's resolved, we can go that way. If not, we'll set it for a trial.
That sounds good, Your Honor. Thank you.
Okay, so let's add it on for next week at.
I run Paige Paracord and Laura's mom. So we make a bunch of rope items and we print.
And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in a car, hitting another car. For sentencing and probation violation. No, oh, I'm sorry. Yeah, sentencing, probation violation, sentencing in 3 files. 22-6457, 23-6764, and 23-6765. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boone County Prosecutor.
Jeremiah Buffalo, work on behalf of Mr. Sayers, who is seated to my right.
Okay, and have you had a chance to review the probation violation report?
Yes, Your Honor, we reviewed it some time ago. The court had been setting these matters out due to Mr. Sayers' other pending matters that are presently here in Sheboygan. We would ask that the court continue to hold that out so we can handle those other matters.
My only problem with that is now it's alleged that he's committing crimes while he's in our jail, so I'd like to get him out of our jail. So I'm going to proceed with sentencing today. It's notice for sentencing today. Any additions or corrections to report?
No, Your Honor.
Ms. Goodrich, any additions or corrections to report?
No, Your Honor.
Or anything you want to say on Mr. Sayers' behalf?
Yes, Your Honor. Mr. Sayers is a victim of addiction, Your Honor, and addiction rears its head in many ways, and it has got a hold of Mr. Sayers. Your Honor, I believe that the best possible solution for Mr. Sayers is to be engaged in treatment, and we would ask.
I think so too. And so I sent him to treatment, and he walked off and absconded. So I don't know how to get him to treatment. I agree 100% with you. The problem that we have is that Mr. Sayers doesn't agree with you or me.
In my conversations with Mr. Sayers, Your Honor, he does. He acknowledges that these acts that are alleged are tied to an addiction, and he needs the help. So, Your Honor, we would ask that the court fashion a remedy that allows for rehabilitation as opposed to punishment.
Mr. Sayers, it's not required to say anything today, but it is allowed. Is there anything you want to tell me?
I'd just like to say that what he said is 100% accurate. I do struggle with addiction. I definitely need help. I want the help. I mean, obviously I've struggled with trying to get there, trying to do it myself. But I have 2 kids that definitely need me, family that needs me. I'm disappointed in myself for everything that I've done. I want to do better. That's all, Your Honor.
Ms. Wiggert's recommendations from the people.
Yes, Your Honor, the defendant is 26 years old. He had 2 prior felonies and 6 prior misdemeanors before these cases. He was given a second chance by entering to recovery court, despite numerous warnings about taking it seriously and being ready for the program. Mr. Sayers has repeatedly said one thing and done another. He had made little to no effort during his time in recovery court, actually incurred another case upon release from jail to start recovery court, and now I received a warrant request today for conduct while in jail, waiting the sentence and having the other felony court case pending. So I'd ask the court to follow the recommendations. Thank you.
Thank you, Mr. Sayers. Please stand for the court sentence. All right, so we're here for sentencing on probation violation in file 6457. You were on probation for resisting obstructing police by fleeing on foot from the police during a traffic stop. It's maximum 2 years. File 6765. You're on probation for fleeing and eluding third degree habitual second, 7.5-year maximum. In that case, you fled in a car during a traffic stop, striking a police vehicle, both high-risk behaviors. In file 6764, you're on probation for delivery of methamphetamine, drug double, maximum 40 years. Possession with intent to deliver methamphetamine, drug double, maximum 40 years. Possession with intent to deliver cocaine, drug double, maximum 40 years. I mean, I've given you so many warnings, and we placed you in the recovery court program despite some of this high-risk behavior. You had multiple violations. We sent you to treatment, and you left treatment and then absconded supervision and had to get arrested. That's not even taking into account that it's alleged that you've committed more than one felony while all that was going on, or while all this case has been going on. Even laying that aside, you've been just out of control, and we have tried to give you every treatment tool in our toolbox. You know, so now I got to reach for the other tools. You know, what your attorney's saying is a great pitch at the initial sentencing, and I bought it, and I put you in recovery court. And you and I have had several conversations, you and Mr. Fagan, you and Nicole. And I don't know why it just isn't sinking in. And it's not just that you're using drugs. I mean, we got deliveries, we got possessions with intent, we got fleeing from police, we got fleeing from the police in the car, hitting another car. They're high-risk behaviors. It places people in danger. Not just you, it places other people in danger as well. So taking all those things into account, in file 6457, I'm going to, that's an advisory guideline range of 0 to 11 months. I'm going to revoke your probation.
Who's coming in the driveway?
And sentence you to, let's see, you have another 85 days credit, I think, because we've been adjourning this. So I'm going to order that you serve 284 days jail, give you credit for 284 days previously served. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. That's 6457. In file 6765, that's the fleeing and eluding, third degree habitual second. The advisory guideline range is 10 to 28 months. I'm going to revoke your probation and commit you to the Michigan Department of Corrections for a term of not less than 28 months, nor more than 7.5 years. Exercising my discretion under the habitual offender statute to increase the statutory maximum to 7.5. We have credit for, by my count as of today, 225 days credit. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. And that is a sentence within the advisory guidelines. In file 6764, on account of, well, I'm going to revoke your probation and any fines and costs and any remain due and owing in the amount of any unpaid balance. For the delivery of methamphetamine charge, the advisory guidelines are 51 to 85 months. The drug double would give me the discretion to double that to 102 to 170 months. I'm not going to exercise my discretion to increase the guidelines, but I am going to exercise my discretion to increase the maximum penalty under the statute. So for that case, Mr. Sayers, I'm going to commit you to the Michigan Department of Corrections for not less than 85 months, nor more than 40 years, with credit for 225 days previously served. That's a top end of the guidelines without the drug doubling. I believe that is proportionate, given his absconding supervision and leaving treatment. And again, I'm not exercising my discretion to double those guidelines. I'm leaving them undoubled, but at the top end. I am exercising my discretion to increase the statutory maximum from 20 to 40 years, however. On the count of possession with intent to deliver methamphetamine with the drug double, the advisory guidelines are 72 to 120 months. I would have it within my discretion to double that to 142 to 240. I'm not going to do that. However, because Mr. Sayers walked off of treatment and absconded treatment court supervision while all of this is going on, I'm going to sentence him to the upper end of the undoubled guidelines and commit you to the Michigan Department of Corrections for not less than 10 years or more than 40 years. Credit for 225 days previously served, increasing the statutory maximum by the drug double statute. And on the possession with intent to deliver cocaine, drug double 40-year maximum, advisory guidelines 10 to 23 months. I'm going to not double the guidelines within my discretion, but sentence you again at the upper end of those guidelines at 23 months to 40 years. Credit for 225 days previously served. Exercising my discretion to increase the statutory maximum, however, not increase the guidelines. And again, top end of the guidelines is certainly proportionate in this case. All right, and Mr. Sayers, you have the right to file, you are able to file an application for leave to appeal if you wish on any of these cases. If you want a lawyer, I give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining that process. One copy is for you to sign. If you want to take an appeal, the other one, we're going to ask you to initial one in all three files so that we have a copy of it. And then we'll just have to writ them out or do it by video to deal with the pending cases, but I'll not have you in our jail any longer, sir. Good luck.
Well, that's it for today, everybody. So the schedule is going to be changing. I'm going to do court cases on Monday, which is going to be the Monday. It's going to be a daily court docket. It's not going to be by judges. And then Saturday is going to be coffee chat. And Sunday will be landlord-tenant docket. So I look forward to doing these changes because sometimes it's really, really hard to get, when you look up these judges, sometimes it's really hard to get it because some places you can't get it. You can't just save it. You have to download it. And I'm not about to pay for YouTube Premium. I'm sorry. I pay for StreamYard and the internet at $145 a month that I spend on this live stream. So I will see you guys tomorrow for coffee chat. Ta-ta, ciao, ciao. Have a wonderful day and a wonderful evening, and I'll see you guys tomorrow.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. You make it better. From the wires tangled up to the broken dreams. You know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.